Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing dividing up the family business, and we are incredibly grateful that you are all able to attend. As a member of the Colorado community for over 30 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to that community. Now, I would like to introduce our presenter today, Katie Ellis. Katie is a partner at the Harris Law Firm. She's been practicing law since 2007. She clerked for the Colorado Court of Appeals before moving to private practice and has been focused primarily on family law since 2008. Excuse me, 2008. She's involved with the American Inns of Court, the Colorado Bar Association, and the Colorado Women's Bar Association. Katie practices as both a trial attorney and an appellate attorney and has represented clients in appeals to the Colorado Court of Appeals and the Colorado Supreme Court. All right, Katie, without further ado, I'll turn it over to you.
Go. Thanks, Izzy. So a couple housekeeping points of my own. Number one, the content of this webinar and all the webinars that the Harris Law Firm provides should not be taken as legal advice, especially as to your specific situation. This and most of the issues we address in these webinars can be incredibly complicated, and you never know how other facts that may be going on in your life or in your situation would affect what our advice might be about the particular circumstances facing your family. So if you find yourself in a situation where you are looking to divide up a family business, you're contemplating a divorce, or you're in the middle of one, please do consult actual legal counsel who can give you some advice about your specific situation. The second housekeeping note is that this evening's topic, dividing up a family business, is intended to address issues that relate to what we consider to be closely held family businesses, right? So these are businesses where one or two of the parties own the business, they run the business, they may do so with a family member or a couple of close friends or other investors. We're not talking about dividing up business interests in a publicly traded company, for example, or a very large entity with multiple shareholders. So just for context, that's what we're discussing this evening. As far as our outline this evening, I'll start by going over the general legal framework that exists when we're dividing marital property at all to kind of give some context. We do have other webinars that address marital and separate property issues more broadly and in a lot more detail. So if that's something that you would like more guidance on, please look for those on our website or watch for upcoming webinars that may address those issues. We will also this evening talk about the question of just who owns the business, what orders a family law court can make about the business, what happens after you get those orders. We'll spend a little bit of time talking about some issues related to business assets, business debts, and business income. We will touch briefly on some issues that come up as to other shareholders that may be involved in the business. We'll talk about enforcement issues and some of the avenues that exist if you have your orders or have agreements about what to do, but one of the parties is not cooperating. And then we'll end with some time for questions. So if you do have questions, please be sure to send those over to Izzy while we're going on, and we'll address them at the end. All right, as far as the legal framework, this is a very, very brief and very, I guess, broad attempt to explain how the division of property works in a family law case in general. So there are two primary places of legal authority we look. One of those is Colorado Revised Statute 1410-113, which governs disposition of property. That is the statute that addresses what factors the court has to consider and what it needs to think about when it's deciding and determining if property is marital, how much it's worth, what to do with it. As a very general matter, understanding there are exceptions, generally, property acquired during the marriage is marital, regardless of who acquired it or how it's titled. So that means that if you started a business during the marriage and used seed money from a job that you had during your marriage, and your spouse has never helped you a day in their life with that business, it has been 100% your baby, you're the one who has brought it into this world and made it the success it is. If you did all of those things during your marriage, that business is probably a marital asset, which means the court has to decide what to do with it if you get divorced. There are exceptions with regards to gifts or inheritances. Those are generally considered to be separate property. It's not often that we're dealing with a situation where a business is acquired as a gift or an inheritance. So I'm not going to spend time on that issue this evening, but just know, in case some of you on this call have never, ever talked with a lawyer before, when you ask a lawyer a question, the answer almost always begins with "it depends." That is certainly true when it comes to classifying things as marital or separate property, but these general guidelines exist that everything acquired or incurred during the marriage is marital, other than gifts or inheritances. If the property is premarital, meaning you already owned it, you had already started this business before you got married, the business is probably going to be considered separate property unless you did something during the marriage to turn it into marital property. And we'll talk a little bit about what that might look like as well. Lastly, know that if you have a prenup, a marital agreement, right? So a prenuptial agreement, a postnuptial agreement, those can also change some of these default rules about whether the business belongs to the marriage or is separate property of one of the parties. The other area that we look when we're getting into property division questions always is Colorado Rule of Civil Procedure 16.2. That rule establishes that parties owe each other and the court a duty of full and honest disclosure, meaning that you have to tell everybody that you have a business. You have to be upfront about providing the documents necessary to value that business. And Rule 16.2 identifies what sorts of financial documents have to be disclosed to one another without even asking, right? There's certain documents you're each going to need to provide. So presumably, if one of you has a business interest or owns a business, that's going to be disclosed to the other party pretty early in the case, so you can make decisions about what to do next with that business. In terms of who owns the business, this is a really complicated and interesting question because we have one answer that applies when we're asking who owns the business in the context of dealing with third parties, right? Lenders and creditors and vendors and all of those things. There's an entirely different answer to that question when we're talking about within your marriage, who owns the business. So as between married parties, the question of who owns the business depends entirely on when the business was created. It also depends a little bit on who is named on the business, but not usually the way people think. So again, like I said just a minute ago, if that business was created during the marriage, it is a marital business. It does not matter if your spouse ever helped you run it, ever had any involvement. Your spouse may not know the name of your business. And if you started it during the marriage, they still have an interest in it as within that context of dividing up marital property, okay? If the business was created prior to the marriage, it is generally going to be considered the separate property of the spouse who created it, unless they did something to add the other spouse to the ownership of the business. So if you, after you get married, draft new articles of incorporation or give your spouse shares in the business or start signing documents and putting their name on the bank accounts and doing things that make it seem as though your spouse also now is an owner or manager of that business, that could change. And so that's the circumstance where who's named on the business starts to matter, right? Only if it was originally separate property and you're trying to demonstrate that now the business has become a marital asset. Remember too, that if it was created prior to the marriage and you never did anything to cloud that, it 100% is in your name only, your spouse is not affiliated with it, the increase in value of the business during the marriage is still a marital asset the court has to address. So it may be that this business is your separate property because you started it 5 years before you got married, but the increase in value of the business is something the court has to apportion when it's dividing the marital estate. When you're dealing with the question of who owns the business as to any third parties, right? If you and your brother open a business together, for example, ownership will depend on the business documents that you hopefully created when you started the business with your brother, or a court is going to have to determine who owns this business, right? So if you and your brother start a business flipping houses and you sign paperwork that says we are going into this business together, we each own 50% of the business, what that means for purposes of divorce court, which is what we're talking about today, is that 50% of that business is owned by a third party and does not belong to the marriage, and 50% of the business belongs to the marriage and has to be accounted for in the division of property. All right. What can a court order? What can't it order? What is it likely to do with the business? These are questions that I think a lot of people have when they are first contemplating getting divorced and worrying about what will happen to this business that they have spent, many years building and investing in. So first of all, what can the court order? The first thing the court has to do with any kind of with any kind of property in a divorce case is determine whether that property is marital or separate. All right. So in that determination, the court is analyzing all the things we've already talked about, right? When was the business created? Did both parties create it together? Did one party get added to the business? Was it, entirely created before the parties got married? Those are all things the court has to address first. And as between the parties to the divorce, the court can make that determination, right? They can say, yes, this marriage or this business was created during the marriage, or it was created before the marriage, and that makes it wife's separate property, or it makes it, this partner's separate property. They can also determine that it was created beforehand, but then one of the parties added the other one to all the paperwork and it became marital property. So that's the first thing the court has to sort out. Once it decides that there is a marital component to the business, the court can value that asset, right? So if this is a business that one of the parties started, there are no other shareholders, no other partners, it is solely owned by the business, then I'm sorry, by one of the spouses, then all the court's going to be doing is determining what is the value of that business. If the business is also owned, like my little house flipping example, by the brother of one of the parties, then the court's going to have to determine what the value of the business is generally, and then decide what portion of that belongs to the marriage. So in my example, if, one of the spouses and their brother started this business and they have paperwork that very clearly says they are 50% owners, what the court is likely going to do is have the parties give it data it can use to value this business. And once it determines that the business is worth $1 million, it's going to say, okay, the whole business is worth $1 million. 500,000 of that belongs to the marriage because it's a 50-50 investment between these siblings. And so what the court's dividing is the 500,000 that belongs to the parties. The court can then allocate that portion between the parties, or it can allocate it to one of the parties, right? So the court can say, yeah, I'm going to give this business to the spouse who started the business with their sibling. That makes sense. If the court's doing that, there's other considerations it's going to have to make that we'll address in a minute. But the other thing that I always like to warn people about is technically the court can also order that the marital portion of the business be sold. That terrifies people. It should. You need to be aware that that is a risk, and that is something the court can do. It's not common. Usually the court is going to be ordering that closely held family business is going to end up belonging to one or both of the parties. But the court does have the authority to order instead that the parties be sold. I have only seen that occur if really it's sort of a last resort, if either the business can't be valued or if it can't be fairly apportioned between the parties. So there was a case quite a while ago that worked its way up to the appellate courts where the business in question was a sort of a summer resort. I think, Dirty Dancing and the resort on the lake where everybody goes for the summer and, they rent cabins and have events and activities and that sort of thing. So there's this big resort on a lake with a bunch of cabins you can rent and activities and things. Neither party was able to give the court any useful answer to the question, what is this business worth? And so the court ultimately said, you're going to sell it. You're going to sell it. And whatever you get for it, you each get half. And that's what I'm doing with it because I don't know what else to do. That also applies if the court is in a situation where it really can't decide which party should keep the business. Again, there's a lot of considerations that would be made and options that would be considered before a court would order the business be sold. But I want to make sure everybody's aware that's at least a possibility. What can't the court do? So number one, the court can't determine the legal rights of any third parties who are not part of the divorce case. So if you have all of these pieces of paper that say that you and your brother own a house flipping business together, and that appears to be true, right? Your brother is on bank statements, your brother is involved in meetings, your brother does some of the work for the business. The court can't make the determination that your brother's right gets extinguished, right? They can't say, you know what, this would be a heck of a lot easier if your brother weren't in the picture. So let's just divide the business between the two of you and cut him out, right? That is not an option. The court can't do that. There are rare circumstances where the court may have to implead or join some third party into the case in order to figure out who owns that interest. I have never actually seen that happen in a family law case. We just don't like having third parties in divorce cases, but it is technically a legal possibility. Another option, and something that's more common, would be to have the parties have a separate civil suit to sort out their ownership in the business. And I have seen that happen. If things related to the business get really messy while the divorce is going on and the business is going to be splitting up, or the parties are fighting about, when you and your brother started this business, you didn't have any paperwork, and your brother is saying, well, hold the phone. I invested all the money in this business and I'm the one who's out there, finding us leads and picking houses and doing all those things. And all you do is show up and sell them. I own 70% of the business. If it can't be determined what portion of the business the marriage owns, you may need to have a separate action with whoever the other shareholders are to figure out what the marriage owns versus what those third parties do. Another thing the court cannot do is award the separate property of one spouse to the other spouse. So, for example, if the court finds that one of the spouses started a business before they got married, the court cannot give that separate business to the other spouse. That's not an option. They also can't order that the separate property be sold. The court does not have jurisdiction over that separate property. So if it was your business before the marriage, all the court can really do is calculate what the increase in value is and address that piece. All right. The question I usually get from clients, though, is what is the court going to do with my business, right? What is likely to happen? And I'm going to start this with a giant reminder about the "it depends" language, right? Every one of these cases is special. It is not possible to know ahead of time what a court is going to do. The best we can do is try to predict what the court is likely to do based on everything we've seen over the years. So when it comes to dividing a marital business, what a court is likely to do is, first of all, always going to be within the court's discretion. The court has tremendous discretion to allocate marital property as it sees fit, which means it can do a lot of things. It can get creative. Typically, courts prefer not to make parties try to run a business together after they are divorced. Hopefully you all can see why that would typically not be a good idea, right? If parties are unable to continue being in a committed, intimate relationship, they're usually also not great business partners. However, if the parties are able to agree that even though we will no longer be living together and no longer be married to each other, we do want to continue running this business together, and we have a plan for how to do that, and they can convince the court that that's a good idea, that is an option, right? The court can agree that, okay, once you're divorced, I'm not dealing with the business because you're each just going to keep your half and keep doing what you've been doing. So that is a possibility. What is more common is that the court's going to award the business to one of the parties. When it does that, it's going to consider a whole host of very practical considerations to figure out what would be the best answer. So in some circumstances, they're going to look at things like who's actually running the business day to day, right? If one spouse has really been doing the lion's share of this, it was their idea, they're the one who really understands the business, and the other spouse was just coming in to provide bookkeeping assistance or to be sort of a receptionist or to, kind of maintain the office and clean things up. The spouse that was really driving the business is probably going to be awarded the business at the end of everything. The court will also consider what's been going on during the divorce process. So if the parties were running the business together and when they separated, one of them said, I can't do this. I can't work with you anymore. This is insufferable. I'm going to go get a job. And they get a job doing something else. Practically, it probably in that circumstance makes sense to let the spouse who's still there running the business have the business and let the one who is working in another field now or has employment pursue that as their source of income. The court will obviously also look at specific considerations that might apply in the industry. As a lawyer, I can tell you as a good example, Colorado law does not allow a non-lawyer to own a law firm. So if I owned my law firm, if I had an equity interest in my firm, even if I acquired that during my marriage, the court could not award that to my spouse if my spouse was not an attorney. Right? Non-attorney cannot own the business. So it wouldn't make any sense to say that your non-lawyer spouse gets the business. There are similar rules for other kinds of entities. And for example, if you're a CPA and you have to have a CPA for the business to work and your spouse is not a CPA, it wouldn't make sense that your, tax preparation company would go to a spouse who cannot file taxes for people, right? So those are all the kinds of practical considerations the court will consider. They'll also look at things like who has the relationships with the clients, with the vendors, with, the people that will make this successful. And so if the parties truly don't agree on who should get to keep the business, those are all issues the court will have to consider. It is also possible, if this is a marital business that belongs to the marriage itself, that the court may consider ordering a sort of partition and agree to split it up, right? And say, okay, for this particular business, we're just going to divide everything. And going forward, you can each have a business doing that type of work, right? Let's say that both parties are CPAs and they've been working together, preparing tax returns for people. Logistically, there's no reason they couldn't each move forward as solo practitioners, right? Or split up the office. Those sort of business divorces can get a lot more complicated when you're then trying to determine, okay, which employees are going to come with me and which are going to go with you? Who's going to keep the physical office space? How do we have this conversation with clients? All those things get a lot more complicated, but it is, again, a legal possibility. If the court goes the route of saying one spouse keeps the business, then the other thing the court has to do is address the equity of that business. So assuming the business has positive value, the court has to determine what that is, and then come up with an equitable way to address the rest of the estate so that each party is walking away with something. Typically, they'll try first to see if there's a way to balance that out. So if you have a business and the marital value of the business is $500,000, the court might say, what other assets do we have that I can give to the spouse who's not keeping the business so that they also have $500,000 on their side of the ledger? If they can't do that, if there are not assets sufficient to create an equitable or fair balance between these assets, then the court may decide that the person who's keeping the business has to make an equalization payment to the other party, which basically means you have to buy them out. You owe them money to compensate for the fact that you're keeping the business and they are not. And so that's another thing the court will have to address, including a timeline for that to happen. And obviously, what that looks like is always going to depend on the circumstances of the case, the liquidity of the business, the cash flow of the business, right? There are a lot of things that will affect how the court's going to do that. And lastly, the court may have to enter orders clarifying which assets and debts belong to the business and which do not. This is a incredibly common issue in family-held businesses, right? Very often we see that the vehicles the parties drive are technically titled in the name of the business, even though they use them for everything from shuttling kids to and from soccer to driving, on vacation. So that's an issue. Often we have overlapping issues where you may have taken out a second mortgage on your home to help fund the business, and we have to start unpacking some of that. So we'll talk a little bit about those when we get into the asset and debt and income issues, but just be aware that that's another order or set of orders that you may see from the court. All right. Assuming the court has done its job in giving you orders that say who gets the business and what you're going to do with it, there are a whole lot of tasks that you're going to take on as homework in order to make that happen, right? Because the court can order that this party is keeping the business, but what the court can't really do for you is all the work of actually making the business divide up. So this is a list of just some of the examples of things that the parties are going to have to do. Again, depending on the circumstance, some cases these are not necessary. There are also things not on the list that may be necessary depending on your business. So obviously notifying any other partners or shareholders of the business that you're going through a divorce and that the business now belongs to one of you and not the other is a pretty important thing. You may have to amend business documents, articles of incorporation, partnership agreements. There may be shares that have to be sold back or transferred or retitled. Updating the Secretary of State to change the registered agents if the spouse who's departing the business was on that paperwork. Removing the other spouse from bank accounts or lines of credit, right? The last thing you want is for the spouse who is no longer affiliated with the business to have signing ability on your bank accounts or to take on additional debt that's going to hurt the business. You also, if you're the spouse who's departing, don't want to be liable for that stuff, right? You want to be out from under whatever debt or liabilities the business may have. You'll need to make sure the spouse who retains the business has all the paperwork necessary to manage things for the business in the future. So if one of you has been doing sort of the day-to-day, you know, work of the business, but the other spouse has been handling all the vendor contracts and stuff, you need to make sure that the spouse who's keeping the business knows how to pay the bills, right? And has the right paperwork so the vendors will talk to them. You'll need to update websites, business cards, marketing materials, all those things to reflect that your former spouse is no longer affiliated with the business. Again, it always depends on the circumstance. So if the business that you're dealing with, your spouse never had anything to do with the business, you don't have to do a lot of this stuff, right? Then it's just on you. You may need to contact business clients to inform them of the change so they knew who to reach out to. You'll probably want to notify your CPA or accountant so they can make sure that all of those, end of year 1099s and W-2s and K-1s and all those other schedules that have to go out are handled appropriately. You'll need to clean up intellectual property issues, right? Does your business hold copyrights or trademarks? And if so, are they owned by the business? Are they owned by one of the parties? You'll want to review all of that and make sure that you're handling that appropriately. And in some circumstances, you may need non-disclosure agreements or other paperwork to protect trade secrets and other things that are particular to your business. So again, this is a very short list in the grand scheme of things. Some of these are completely unnecessary for some cases, but we could probably spend the rest of the evening brainstorming other things you might have to do if you're transferring a business from one spouse to another. All right, some of the issues that come up with assets. Obviously, the first thing is just making sure you know what the business owns. I say this with all respect for business owners. I have seen the gamut of sort of responsible paperwork for business owners, right? I get some people come in that have never had any kind of asset debt ledger. They have no real profit and loss statements, right? They are just taking work when it comes in and doing their best to estimate taxes and floating through with things scratched on napkins. I've seen others that are very formal about having all of this stuff and have bookkeepers on staff and have CPAs that guide them through all of the tax issues. So if your business is one of those very organized, well put together ones, you probably already have this list in QuickBooks or some similar bookkeeping software all ready to be, printed out and used to address the business value. If not, you're going to start making a list. Does their business own real property? Does it own vehicles, bank accounts, investment accounts? Does it hold any physical assets like tools, supplies, product? If you're a business that sells things, right? What does the business own? Intellectual property, again, trademarks, patents, copyrights, customer lists, right? That is a thing that is considered to be property of the business, right? So your list of who your customers are. Contractual rights. So if you have for example, if you're a talent agent, right, and you have the exclusive contractual right to market one of your artists, right, that is an asset that your business holds. Trade secrets, right? There's all of these different things you have to start kind of thinking through. And then you need to ask yourself, how are those assets titled? If it's something like the truck that your business uses to get supplies to and from places, and it's titled in the other spouse's name, you're going to need to fix that, right? If it's titled in the name of the business, you probably don't have to worry so much because it belongs to the business. So once you've established who owns the business, the rest of it follows. So you'll have to deal with that. You'll also want to make sure, again, that you're removing the departing spouse's access to accounts, notifying relevant third parties that former spouse no longer has the legal authority to act on behalf of the business, to bind the business contractually, to obtain information about the business. So cover your tracks in terms of making sure that once that spouse leaves the business, they really don't have any ability to interfere or manage the business. Debts, substantially similar analysis, right? What debts are there? Debts we very often see with businesses, there may be mortgages, right? These are secured debts, vehicle loans, equipment loans. If those are the case, if you own the asset, but you're still paying for it, those are debts that typically attached to, I mean, they're already attached to the asset. So courts almost always, if you're keeping the physical property, like the office space or the warehouse, you're also taking on the mortgage that goes with it. That does get complicated, though, as we talked about a little bit ago, if you have leveraged personal property for the purpose of the business. So if you took out a home equity line of credit on your house and you've been using the home equity line to float business expenses, the court may have to get creative, or you and your spouse may get creative when you're coming up with a separation agreement about who's actually going to be responsible for that home equity line. If there's a way to refinance it and remove it from the home, if there's a way to freeze it so it can't be spent up again. But that's one of the issues. Unsecured debts, right? If there are credit cards that the business holds, if there are personal loans, loans from family and friends, right? And making sure that we know who's going to be responsible for those loans, those debts, once the parties are divorced. If they're clearly owed to the business, they're typically going to attach to the business and go with it. But you want to make sure that, again, if it's a credit card that was used exclusively for business expenses, but it's titled in the name of the spouse who is departing the business, it's a great idea to come up with a plan for refinancing that debt in some way to remove the spouse who's no longer going to be part of the business. Other liabilities, there may be leases for equipment or vehicles, rental contracts for offices, warehouses, etc., service contracts with different vendors or customers. All of those are things you're going to have to sort out to make sure that the business holds them, you know where they are, and whoever's keeping the business is able to honor those so the business itself doesn't get harmed. Again, just like with the assets, you have to deal with title for those and make sure that the right person ends up taking on those debts. Failing to close the door on that can really damage both sides. The business can obviously be damaged if the spouse whose name is on a debt isn't paying it and it reflects badly on the business, or if they continue to incur debt and drive the business into the ground. But the spouse that's departing can also have that weight on their credit score, right? If their name is on the mortgage for the office, if they've personally guaranteed that, that's going to show up. And when they try to go buy a home, it's going to be difficult because they'll have this big loan that already shows up on their credit report that it looks like they're liable for. So addressing those title issues is a whole nother thing that courts sometimes have to help with. All right, income. One of the first questions is who owns the income for the business? You will definitely want to make sure that either your separation agreement, if you're fortunate enough to be able to settle, or the permanent orders the court give you are very clear about the effective date that ownership of the business changes, especially if the other party has been some sort of stakeholder or employee of that business. So your CPA is going to need to know how income for the year that the decree enters should be apportioned, right? If you get divorced in July, and from January through July, you two were equal partners in this business, you were both earning money and doing all of that, your CPA is going to want to know, okay, at the end of the year, how are we handling this, right? Are we treating that income from January to July as belonging to the spouse that's departing? And if so, are they getting issued some sort of 1099 or K-1 or W-2, depending on what their relationship with the company was? Or are we treating all the income from that year as belonging to the spouse who's keeping the business? So those are messy questions. I strongly recommend working with a CPA, someone who understands these issues, to make sure that you are handling it appropriately. And bear in mind, those questions also have implications for spousal maintenance and child support. So it can get really messy if you don't have a good plan for how that's all going to work out. Related to that, and I probably should have had a separate slide about this, you're going to have to address tax issues, right? And who's ultimately going to be responsible for any taxes the business owns at the end of the year. Again, if the two of you were joint partners on this venture until October, it may not feel fair that the spouse who's keeping the business pays all of the tax that may be owing for the business in the previous year, especially if you tried to finance your divorce by not paying your quarterlies the way that you should have. So just things to consider and be on top of as you're heading into tax season. All right, one of the complicating factors with closely held family businesses is that we often have some other shareholder who's not just one of the spouses, right? It is pretty common for us to see the parents of one of the party's children, siblings, friends, or truly neutral business partners in some circumstance that have an interest in the business as well. When that's the case, it's important to remember and understand that the rights of those third parties are typically not affected by what happens in the divorce case. If it is clear that they own a 30% interest in the business, they should still come out of this owning a 30% interest in that business. However, that doesn't mean they're not affected by the divorce. And so some of the potential complications that we see are, frankly, so just to start with, some business documents have specific language about what happens if one of the parties, sorry, the shareholders in the business gets divorced, right? They may have limitations internally on what documents they're willing to share to value the business, what information that other spouse is allowed to get, whether the ownership of the business can be sold or transferred. Some of them have buyback clauses that if you are trying to sell your interest, you can only sell it back to the other shareholders and you can only sell it for $1, right? Whether those are enforceable is a whole other headache, but just understand that the documents that were executed when people formed their business or added new shareholders, new investors, new owners are going to matter as well. Independent of that complication, divorce is disruptive. If you haven't started the divorce process and you are under the illusion that it's super easy and straightforward, I hate to disillusion you. It can be very, very messy and very disruptive. Among the ways a divorce can affect and disrupt a business, number one is the business will probably have to be valued. And that means that people are going to be coming through wanting copies of the books, right? You may have business valuators doing audits, looking at bank statements, wanting to talk to key personnel, to getting a copy of the profit and loss statements and the asset debt sheets and all of the other ledgers for the business. And that can be a real nuisance, and it can definitely unsettle the other owners and employees. Sometimes you're also dealing with loss of key personnel, right? When this is a closely held business, if one of the spouses was actively involved in the business and is now leaving, that can be disruptive, right? You may be losing your best salesperson or the person who kept the books, and now the books are a mess because they stopped helping in March when you filed for divorce. So that can be really messy. Sometimes, again, if this is a family business and you have close friends or family that are also involved in the business, they may leave. They may not want to be in business with their sister's ex-husband, right? So you have other people who may also be leaving, which can destabilize the business. There's also just the reality that divorce is incredibly distracting and time consuming for parties. And so their own individual performance may suffer while they're going through the divorce. They may not be closing deals the way they were. They may not be as on top of their game as they used to be. And so the business itself may be losing revenue or losing clients or customers just because the parties are really struggling with everything else that they're dealing with. So all of those things can impact the business. We also have issues with losing customers, right? If the departing spouse intends to start a similar business, there may be some competition issues and the business itself may lose some value if it is sort of splitting itself. And then the value findings can also be something that can cause problems for a business. If you're having the business valued as part of a divorce, that valuation report may have some significance if the business is also trying to obtain credit, or it may affect the business's attractiveness to other investors. So just be aware that all of that is part of the fun of dividing these businesses. All right, last topic before we get into questions is some of the enforcement issues that we deal with. So what I mean by this is you have orders, you know who's supposed to get the business, you know what's supposed to happen with the various accounts, and you're just not getting it done. You're having a hard time getting the other spouse to commit, to cooperate. And as a result, there's accounts that are supposed to be transferred to the business that hasn't happened. It can be really messy and frustrating. And so the question often becomes, what do I do? Some of the tools that are available, the one that usually jumps to people's mind first is contempt, because it's the phrase they hear in movies and legal dramas. Contempt is a remedy. It is a tool, I should say, that exists in the process. It is one of my personal least favorite legal tools to use for a whole lot of reasons. And I think we do other webinars just on the issue of what is contempt and why would I want to use it. So that is an option, but it is usually not the best one. One option that exists for some circumstances is a motion pursuant to Colorado Rule of Civil Procedure number 70. That motion allows the court to transfer title or execute paperwork if a party is legally obligated to do so and is refusing. So for example, if there's a vehicle that is owned that the business uses and that the court has emphatically decided belongs to the business and needs to be transferred to the business, but it is currently titled in the name of one of the spouses, and they are refusing to sign the title, you can ask the court to have the clerk of court sign that title in their place. And so that is something that will sometimes shortchange or I guess accelerate the process, right? Help you get over someone not cooperating. With some more limited application, you can do that for other legal documents that might need to be signed. Title paperwork is usually the most clean, but this exists. In some circumstances, you may need a cease and desist order if you have the other party trying to capture business or take clients in a way that is violative of whatever agreements you have about the business. If they're harassing the business, if they're trashing it and making it look bad on social media, so that kind of thing can come up. We will sometimes see separate civil suits where the parties have to then go fight in civil court in order to divide up the business assets or address some of the debt issues. In addition, depending on the circumstance, you may need to take other action to address intellectual property that should belong to the business, or litigation concerning tax filings, right? So if the business has a lot of tax liability, if that tax liability arises out of actions that occurred during the marriage, there's other steps that may need to be taken that are outside the scope of what your divorce court can handle for you. So that's just a brief rundown of some of the sort of enforcement issues that may come up. All right, that was a whole lot of material, and we got through it in about 45 minutes. So that leaves us some time for questions.
Thank you so much, Katie. All right, let's get to the questions. Again, if you guys have any more questions, we have a couple, but if you have any more, please go ahead and throw those in the Q&A at the bottom of your Zoom screen. All righty, the first one is, how can we tell what the business is worth? We deal mostly in cash.
So business valuation is one of the more expensive but important parts of a divorce process when you have a business that may have value. First of all, I very often get the question, well, or not even a question, usually it's an argument from my client that my business isn't worth anything because I'm the only one who does any work. And if I stop working, then there's no revenue. So that means the business has no value, right? Probably not true. Businesses own a lot of things, right? Even just the goodwill associated with the business, its name recognition, all those kind of soft, fuzzy things. But then again, all the assets we were listing. So figuring out what the business is worth is a critical first step. When the parties don't agree and we don't have an easy way to value it, like that they just had it valued for investment purposes, we can hire a business valuator who will go in and look at bank statements and income analysis and any other financial documents that will help them determine what the business is worth. They have a methodology for doing that compares businesses to other similar businesses. They look at industry trends. There's a whole lot of factors that go into their analysis of what they think an individual business is worth. So if the parties don't agree, that is usually the way we address that. When we have the additional complicating factor that it's a cash business, I will be honest, it's hard. One of the reasons we like business valuators is that they tend to be able to say, and here's a good example, was our firm was involved in a case relatively recently involving a nail salon, right? And that again, it's a big cash business. So part of the business valuation in that case looks not only at how that business, like what its books are reporting, but it draws on data from the industry and compares it to other nail salons and says, okay, a nail salon that's been in business for this long in this city or town that has this sort of a customer base and this many, employees that are actually performing services for clients, this would be what we would expect revenue to look like. Sometimes it's based on that type of business tends to be 30% credit cards and 70% cash, and they can kind of extrapolate out by comparing to other businesses, right? Other restaurants, other lawn mowing services, right? Whatever the business may be.
Great, thank you. Okay. What do we do if we do agree? Do we have to use a business valuator?
Yeah, no, you do not. It is great if you can agree that that is a much cheaper option. I will tell you, and the court will at least want to know, was there a basis for that, right? And there's sort of obvious red flags that come up. If there are no red flags, then the short answer is yes, you can agree, and the court will be so happy not to have to help you with that process. But if, for example, one spouse comes in and says, yeah, I've had this business for 40 years, and I have about 400 clients at any given time, and it's a successful business, and I earn $300,000 a year running this magical business that I have, but the business doesn't have any value. And the other spouse says, okay, that makes sense. And the other spouse is not financially savvy, the court's probably not going to let that slide. Right. But if there's a rational basis for it, if the parties were both involved in the business and they say, yeah, we've done some analysis, we think this particular business is worth about $150,000 based on the fact that we've done our research. If the parties are comfortable with that, the court's not likely to interfere.
Okay, great. We have two triplexes. My husband of 34 years and I enjoyed income from both of them. I will get one triplex and he will get the other. He will keep and live in his. I would like to sell mine. If I sell before the divorce is if I sell before the divorce is final, is he required to pay half of the gains taxes?
So as a precautionary note, if you've already filed for divorce and the divorce is pending, you should not sell the property unless the other side agrees or the court gives you permission, because there's an automatic temporary injunction that goes in place while a case is pending that prevents major, really instructs you not to get rid of marital property like that. But assuming everybody agrees that that should happen, I hate to do this, but the short answer is going to be it depends, right? And so that tax liability, the gains are a marital debt, the same way that the triplex itself is a marital asset, assuming that these were both purchased during the marriage. And so the court's going to have to decide what is a fair way to handle all of that, right? Presumably, if the other triplex also has gains, it might be fair to say, well, when he sells that one, he's going to have to realize those gains all on his own. So the court may treat it as a neutral issue. If the court says, what we're going to do here is one of them is being sold, the court can address the question of the tax liability. And it's something you should certainly raise so that at least you know the answer to that. And next April 15th, you're not fighting about whether your spouse is supposed to contribute to some of that.
Awesome. Okay, we've got one more. Get any more questions in if you have them. Um, do you have any tips for dealing with the emotional aspects of splitting up a family business? Both of my kids work in our business.
This is one of the hardest aspects of this, I think. We see sometimes the business we're dealing with is that one of the parties decides to go, start selling Mary Kay products or something, and there's no real emotional attachment or involvement with the family. But very often we're seeing businesses where the kids are involved. And maybe it's even the plan that the kids are going to take over the business. The children may already own part of the business with the idea that when mom and dad retire, or when both moms retire, or whatever, that the child will own that business. It can be a form of succession planning. So it's a hard question. I think what makes it particularly hard is that generally it's not great when kids are in lawsuits involving their parents, right? That kind of sucks. None of us really like to see that. Sometimes it's the only way. I've had a very messy case recently where one of the parties own a business with one of their children, and one of the parties is basically taking money out of business accounts that he shouldn't be. And it's a really difficult decision for the other spouse and the child to sort through. Well, we don't want to sue. Like, I don't want my kid to sue his dad, but how else do we fix this? I think the best advice I can give is making sure you're all upfront ahead of time. If you can work out together a reasonable succession plan that involves one of the parents stepping out, it may also, depending on the age of the parties, the success of the business, the age of the children, it may be a good opportunity just to turn the business over to the child, and have both parents walk away so that they're not fighting over the business or having those complications. But I think some level of transparency so that the other family members are not blindsided by what's going on and have some sense of control over what's happening. And then be mindful of the fact that if the two parents are really nasty to one another in the divorce process, that child may not want to be part of the business anymore. And so that may be a complicating factor for people as well. But yeah, I mean, the best advice is, as with all cases involving children, do your best to put on a united front when working with your kids, and try not to drag them down in the mud of, sorting out the dissolution of the marriage.
That's excellent advice, Katie. We really appreciate your words of wisdom tonight. Well, not advice. Those are excellent things for people to consider if they're in a similar situation. Definitely not advice. But any final words before we close up tonight?
No, I just want to thank everybody again for attending. We love doing these webinars. If you have not joined us for one of these before, please do watch for the requests for feedback. We love to hear how we're doing. We love ideas for other things people would be interested in. And as I'm sure Izzy will remind you, if you're having actual legal issues that need addressing, please do reach out to a lawyer, whether it's one of ours or someone at another firm. Get some good advice from someone who can actually look at your situation and advise you about what might happen with your business.
Awesome. Thank you, Katie. Thank you all for attending this evening. And as Katie mentioned, as a thank you for attending, we'd like to offer you a free consultation so you can discuss those more specific aspects of your case with an attorney. Just give our offices a call. The number's on that screen there. It's also in the chat, or you can Google us. Give our offices a call and give them the code WISER together when you're scheduling that consultation, or just mention the webinar and they'll be able to waive that fee for you. We wish you peace. And we hope to see you at another Wiser Together webinar. Have an excellent evening, everyone.